He inherited nothing, then discovered his family's $47,000 secret. A family dinner turned into a courtroom battle over $47,000. And by the time the truth came out, nobody in that family would ever sit at the same table again. The plaintiff had spent 12 years driving for a rideshare platform in a mid-sized Midwestern city. Long hours, unpredictable income, the kind of work that wears a person down slowly. When his uncle, his mother's younger brother, the one who had made something of himself in commercial real estate, passed away in the spring without a spouse or children, the family assumed the estate would be divided simply. The uncle had always been close with the plaintiff. Holidays together, phone calls every few weeks. There was even talk, according to the plaintiff, of being named in the will directly. What the plaintiff received instead was a verbal promise and a wire transfer that never came. The defendant was the plaintiff's older cousin, the deceased's niece from a different branch of the family, a woman who had served as the informal executor of the estate before a formal administrator was appointed. She was organized, detail-oriented, and by her own account, the only one who showed up when the hard work needed doing. She arranged the funeral, she sorted through 40 years of paperwork in a house that smelled like mothballs and neglect. She spent 6 weeks of her own time doing what no one else volunteered to do. According to her, she deserved every cent she kept. The plaintiff's case rested on a single document, a handwritten note found tucked inside the deceased's desk drawer, dated 14 months before his death. In it, the uncle had written that he intended for his nephew, the plaintiff, to receive $47,000 from the sale of a parcel of undeveloped land outside the city. The note was not a formal will, but it was signed, dated, and witnessed by a neighbor. The plaintiff argued that when the land sold for $190,000 shortly after the uncle's death, the defendant, who facilitated the sale, had quietly redirected those funds without disclosing the handwritten note to the estate administrator. He claimed he only discovered the note's existence by accident, when a different family member mentioned it at the memorial reception. He stood at the plaintiff's table and told the judge he wasn't greedy. He said he just wanted what his uncle meant for him to have. The defendant's attorney painted a different picture entirely. She acknowledged the note existed. She did not dispute its authenticity. What she disputed was the plaintiff's clean hands in this story. Because in the 18 months before the uncle died, the defendant had been the one driving him to chemotherapy appointments. She had organized his medications. She had quietly covered $8,400 in home care expenses out of her own pocket when the insurance lapsed. The plaintiff, her attorney noted, had visited his beloved uncle exactly twice during that entire period. Both visits lasted under 3 hours. The defendant wept on the stand. Not performatively, quietly, in a way that the courtroom seemed to lean toward. She said she never hid the note. She said she gave it to the estate administrator on the 3rd week of the process and assumed it had been reviewed and dismissed as a non-binding expression of intent, not a legal instrument. Then came the document that changed everything. The estate administrator, called as a witness by neither side, subpoenaed by the judge following a procedural inquiry, produced a time-stamped email chain. In it, the administrator had explicitly told the plaintiff about the note 6 weeks before the lawsuit was filed. The plaintiff had responded asking whether the note carried legal weight. The administrator said probably not, and the plaintiff had written back in his own words, "Then I guess we move on." He had known. He had decided to move on. Then, when money got tight 8 months later, he changed his mind and filed suit anyway, claiming he'd only just learned of the note's existence. The judge ruled in favor of the defendant. The plaintiff was awarded nothing. Court costs were split, which the judge noted was more generosity than the plaintiff's conduct warranted. In the weeks following the verdict, the plaintiff's mother stopped speaking to her nephew's family entirely, blaming the defendant for humiliating her son publicly, regardless of what the emails showed. The defendant sold the parcel proceeds, paid herself back the $8,400 in care expenses she had documented meticulously, and donated the remainder to a hospice organization in her uncle's name. The plaintiff filed no appeal. The rideshare app still shows him active in the same city, same hours, same routes. Here's the question the case leaves behind. When someone chooses to walk away while a family member is dying, and then shows up once the estate is settled, how much of what they're owed is money and how much of it is guilt?